Recording in progress.
So you're Matthew DeWitt, is that correct?
Yes, sir.
Have you received a copy of the complaint?
Yes.
We're on the record in case number 25-CRI-085, cases captioned State of Ohio versus Matthew DeWitt. We're scheduled today for bond stating a complaint filed according to this date, that being June 5, 2025. We're conducting this hearing by video. The State of Ohio is represented by Assistant Prosecutor Matthew Metcalf. The defendant is also present. Mr. DeWitt, do you have any objection to the court conduct this hearing by video?
No, no.
And again, for the record, you have received a copy of the complaint, is that correct?
Yes.
The complaint charges one count of felonious assault, a felony of the second degree. Count one states in that on or about June 3, 2025, Nashland County, Ohio, Matthew J. DeWitt did not only cause serious physical harm to the alleged victim. Sir, do you understand what's being alleged in count one?
Yeah, Your Honor.
During the course of these proceedings, you have the right to remain silent. Anything you say can and will be used against you in future court hearings. You also have the right to be represented by an attorney. If you don't think you can afford to hire an attorney, the court can consider you for court-appointed counsel. If you qualify, the court will appoint an attorney to represent you in this case. There's a $25 fee for court-appointed counsel. Further, since you're charged with a felony offense by complaint, you have the right to a preliminary hearing. That's a probable cause hearing. And finally, sir, you have the right to a jury trial. Sir, do you understand your rights?
Yes, Your Honor.
Sir, do you want to be represented by a lawyer in this case?
Yes.
Can you afford to hire one or should be considered for court-appointed counsel?
No.
Do you want me to consider them for court-appointed counsel? Is that correct, sir?
Yes, Your Honor.
Sir, what's your date of birth?
March 13th, 1996.
What's your address?
722 North Market Street, Loudonville, Ohio, 44842.
What's your phone number?
908
I'm sorry, sir. You broke up there. Can you start over?
419 908.
What's the last four digits of your social security number?
6265.
Do you currently receive any benefits such as food stamps, partly to veterans benefits, Medicaid, SSI, SSD, or how it works for a Santana fund? Are you employed, sir? I'm sorry, sir. I didn't pick up your response. Okay. If you had any income whatsoever in the last 30 days? I'm sorry, sir. Didn't pick up your response again.
No, I haven't.
Okay. Have you received any benefits like unemployment compensation, workers' compensation, child support?
No.
Are you married, sir?
No.
Do you have any bank accounts like a checking account, savings account, money market account?
No.
Do you own stocks, bonds, CDs, anything like that? Do you have any cash at the jail at home or elsewhere?
No.
Sir, do you own anything you could immediately sell to hire an attorney? Okay. So you do qualify for court-appointed counsel. I'm going to appoint attorney Zach Miranda to represent you in this case. We'll notify him the appointment. He'll be present for the next hearing. We are going to set up bond today. Mr. Metcalf, what's the state's position on bond?
Thank you, Your Honor. The state's going to be requesting a $750,000 cash bond in this case. I see that it is currently one count of felonious assault, but that is very likely to change, at least with more counts and hopefully not more significant ones. Factually, I think the court should know in setting a bond for this case, Loudonville police were dispatched to a domestic violence call where the victim may not be breathing. They get there. Mr. DeWitt was in the front yard, leaning on a fence, shirtless, covered in blood. The victim of the offense is his mother. He had aggressively beaten her, and he was aggressive with law enforcement officers when they arrived on scene. They had to deploy 2 sets of tasers on Mr. DeWitt. He was telling them to kill him at that point and did not seem to want to be apprehended. They did a search of his arrest, and there was methamphetamine found on his person, as well as a search of the house and methamphetamine found in his room there. He does have criminal history. This will be, well, he's been to prison 4 times. He went for aggravated arson for 5 years. He went for possession of drugs in 2018. The arson was 2013. Possession of drugs in 2019, and then he had multiple drug possession offenses in 2022, all of which he went to prison for. The victim in this matter is still currently in critical condition. If that worsens or gets worsened, he could be facing possibly a murder charge. In this case, is as far as felonious assault go, it's probably one of the most egregious forms of the offense that you could commit. I think if found guilty, which the evidence is very strong against Mr. DeWitt, but if found guilty, he'd be facing a very lengthy prison sentence is what the state would be seeking. Because of that, because of his history, we are asking for that high cash bond and no contact with victim or victim's family.
Thank you, sir. Mr. DeWitt, as far as today, the court is only setting bond, of course, not addressing the merits of the charge. Again, you do have the right to remain silent. Further, sir, bond is something the court can always reconsider. So if you want to speak with Attorney Miranda before addressing bond, that's fine. Sir, is there anything you want to tell the court today before I set bond? Again, you do not have to. Okay. Court's going to set bond as follows, sir. To be released while the case is pending, I'll have to post 2 bonds. First bond is a personal reconnaissance bond. That's your written promise to the court to appear for all future hearings. If you would fail to appear for a hearing, you could be prosecuted for the separate felony offense called failure to appear. That's a felony of 4th degree. So in addition to this case, court's also requiring a posted bond amount of $750,000. That can be posted with a surety bond, cash bond, or real estate posting. If you post bond, you're subject to the following conditions. 1, you're not to leave the state of Ohio while the case is pending. 2nd, you must appear for all future hearings in this case. 3rd, you must keep the court advised of your address and phone number at all times. 4th, you must obey all laws and orders of the court. 5th, you're not to use, consume, or possess any alcohol or drugs of abuse. You'll also be subject to RAM, drug and alcohol testing at your own expense. Further, sir, if you post bond, you must enroll in the court's drug and alcohol testing program. Further, sir, if you post bond, you will be subject to GPS monitoring. What that means, sir, if you post bond or bail stick up to GPS monitor, you have to weigh that while this case is pending. While you're on GPS monitoring, you'll have a curfew. You must be at your approved residence 24 hours a day, 7 days a week. Further, sir, you'll be responsible for all costs associated with the GPS monitoring. Finally, sir, you'd have no contact whatsoever with the alleged victim. Any member of the alleged victim's family, you're not to be within 500 feet of her residence. Mr. DeWitt, do you understand the condition of bond?
Yes, Your Honor.
Okay.
So,
Mr. Metcalf, would you be available tomorrow at 2:30 p.m. for an initial appearance hearing?
Yes, Your Honor.
Mr. DeWitt, your next court hearing is going to be tomorrow, June 6, 2025 at 2:30 p.m. We're going to do that by video. Mr. Metcalf, anything further today?
No, thank you, Your Honor.
Thank you all. We're adjourned.